One of the most common questions that I'm asked is, how does a medical malpractice trial actually proceed? My name is Barry Washor, and I'm a medical malpractice attorney. A couple of months ago, I was on trial with a case in which I represented a woman who suffered from a condition known as gestational hypertension. As a result of her pregnancy, her blood pressure rose. The treatment for this at the end of her pregnancy was to immediately deliver the child through or via a cesarean section. This was done, but following the delivery of her child, she still continued to have high blood pressure. Nevertheless, the physicians at the hospital discharged her after 4 days, and they didn't provide her with good advice at that point. They simply told her to come back in 2 weeks and see them at their clinic. Well, 4 days after her discharge, she suffered from a major stroke, which left her paralyzed on half of her body. Now, let me explain to you some of the aspects of the trial, and in fact take you along a journey which we went through recently. The trial begins with what is known as the voir dire. This is the jury selection process. Many attorneys will tell you that this is the most important aspect of any trial, because this is where we get to speak with members of the community to see if in fact that if they can be fair and impartial and objective-minded in the case. This particular case that we recently proceeded on trial had a particular problem, which was that we were representing a young woman that was an undocumented worker. And we were in a venue in a county where folks weren't all that sympathetic to people that worked in this country without having obtained citizenship. Jury selection took approximately 3 weeks. We interviewed literally hundreds of people until we were assured by the jurors that we ultimately selected that they would be objective-minded and they would keep an open mind and listen to the facts and the evidence in the case. After we selected the jury, we met with the trial judge. And as is often the case, this judge knew nothing about this case. This judge had never had any involvement with this case until this moment. We then spent a considerable amount of time explaining to the judge the nuances of the case and why we felt that the doctors were responsible. At the same time, the physician attorneys were explaining to the judge why they felt that they weren't responsible for these horrendous injuries sustained by our client. The trial then began with opening statements. I presented our case first. I explained to the jury that this was almost like coming attractions in a movie, that I was telling them what to expect, what would be coming, what they would see during the course of the trial. I told them that they will find that these doctors were negligent, that there was no compelling reason, there was no medical reason why this woman should have been discharged from the hospital when she was, without medication, without adequate follow-up, in light of the fact that her blood pressure was so dangerously high. I explained to them the medicine that would be involved in this case. I explained to them what a stroke was and why it occurred in this case and why it was preventable and why the doctors could have avoided this if they had adhered to accepted practices and procedures. After the opening statement, we called as witnesses. We subpoenaed those very doctors that rendered the care and treatment to our client. And I was able to cross-examine them. And that's asking the difficult, tough questions. That, yeah, sometimes those doctors were very uncomfortable when they were faced with these kinds of questions. But that's how we get to the truth. And we established what happened. We then presented what we call liability witnesses. These are physicians, in this case, board-certified physicians, that came in and they testified. And they explained and they told this jury why the doctors had committed malpractice, what they did wrong. Our client testified, as did members of her family, to explain the devastating injuries that she sustains and the challenges she faces every day in life. We then presented damage experts. These are physicians that actually treated her, cared for her, and were able to tell us what kind of medical care and attention she was going to require for the rest of her life. Then we stood and we told the court and the jury that we rested, that we had presented all the evidence that was necessary and required. Well, the defendants, they tried to defend the case. They put a couple of liability experts on to say that they didn't think that the medical treatment that was rendered was a deviation or a departure from good and accepted practice, but it didn't seem to make much of an impact on the jury. Certainly, when we got to the next phase of the trial, it was pretty evident that the jury was no longer interested. This last part were the summations of the closing statements, where I had an opportunity to again address and speak to the jury and explain to them why our client was entitled to compensation, and to remind them of the elements and the proof that I had told them back in the opening statement was going to be shown to them. And that, in fact, we did show it to them. The final part of the trial is when the judge then explains the law to the jury and tells the jury how they come about making a decision, what laws they are to base their findings on. Well, during this process, the insurance companies finally decided to offer a settlement that would fairly and reasonably compensate this woman and her family. And they did. And I can say to you, she's much more comfortable now. If you have any questions regarding a medical malpractice matter or feel that you've been the victim of medical negligence, call me. My name is Barry Washor. Thank you for watching.